Welcome to the Bail in the Midwest podcast, hosted by Shane Rolf.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 35 years. So, in the criminal justice system, the people are represented by two separate yet equally important groups: the police who investigate crime and the district attorneys who prosecute the offenders. This quote, obviously, is from the television show Law and Order, and sadly represents the sum total of what most people know about the criminal justice system. But the criminal justice system is made up of much more than just cops and prosecutors. Defense attorneys are a must, plus all the various support functions: bail bondsmen, probation officers, court reporters, and many others have roles to play. But the one role, the quote-unquote high priest of this secular religion that we call the criminal justice system, is somewhat shrouded in mystery. And of course, I'm talking about judges. Judges, in theory, are a co-equal branch of government on par with both the executive and legislative branches, but they are the one branch of government that most people understand the least. They are the least transparent and the least accountable to the people. With any luck, my guest today can help us peek behind the curtain of the judicial branch. The Honorable David Platt has worn many hats in government and the criminal justice system as well. He was the city attorney, a city commissioner, and the mayor of Junction City, Kansas. For those unfamiliar with the area, Junction City is home to Fort Riley and the Big Red 1 1st Infantry Division. He was also a private practice attorney and was an assistant county attorney for Geary County, Kansas. And finally, after all that, was a district court judge for 22 years. Judge Platt, welcome to the podcast.
Thank you. Good morning.
Well, good morning to you. So maybe give us a little bit of your background in a little more depth. I saw that your retirement notice said that your family had been practicing law in Geary County for at least 100 years.
Yes, my grandfather started practicing in 1908 in Junction. He graduated from Washburn. Matter of fact, he and a very good friend that he played football with at Washburn also came back about the same time, and he was an MD. And they both started practicing there in Junction after playing football at Washburn while they were in law school and med school. By the way, Washburn had a med school back in those days. But he started practicing there in 1908. A few of my law school professors still tell stories about Platt, and so I heard about those things. But he was a state representative and then a state senator, county attorney, all those things. My father came back after World War II. He was a Navy pilot and finished up his undergrad and law school at Washburn. He'd started at K-State. And then I came back after undergrad at K-State, graduated from Washburn in the mid-70s and practiced with my dad for a number of years. Besides private practice, I did start prosecuting. I got contacted by the then county attorney and started as an assistant there while I was still, of course, county attorneys in Kansas are a part-time job. So I still had private practice, but prosecuted. And in Geary County, with Fort Riley right next to it and Interstate 70, we had a huge caseload. And there were two of us that handled a docket that was, I think, caseloaded similar to Douglas County, Lawrence. So that was quite a bit for two of us. I did that for 4 years. And I was actually on the city commission at the same time. At least part of that. And I was commissioner or mayor when I was 26, 27 years old. Then I did a stint for about 4.5, 5 years as city attorney after I'd gotten off the commission. And then later came back Chris Biggs asked me to come back as a prosecutor, and I told him I could give him 2 days a week because of my private practice, but obviously more than that. And so came back and prosecuted, and then in '92 I got appointed to the bench as a district judge, a new position that was created or moved from Pratt to Junction, Erie County. So then, as you mentioned, I was on the bench for about 22 years, and I'd done criminal defense work. Obviously, I'd done prosecution. We owned a bank. I handled those types of things. My father mainly did business type stuff, probate, all of that. I doubt that he'd handled a criminal case since the '60s, but knew all the history, those types of things. So I was very lucky to have my father there, and a great mentor and great resource for me, and also able to support me while I was handling very low paying jobs as an assistant county attorney. So
well, and that's one thing that lawyers, especially lawyers just coming out of law school. I know we talked to Vanessa Reevely about that last episode, coming out and getting a job with the district attorney's office. But if you're going into private practice, especially if you're going to focus on criminal law, and it's not as easy now as it was, say, 25, 30 years ago with the rise of the public defender's office. Used to be you'd come into our first appearances here in Johnson County, and there'd be 10 young lawyers sitting there just waiting to see if they could pick up that appointment. Okay, I need a court appointed attorney. I'll pick you. Right. And so the public defender's office is kind of eating away at that in a lot of places.
Well, see, Erie County was the pilot project for the public defenders in Kansas. George Scott was the first public defender. So we'd always had that, but they always had conflicts. So right. Everybody was on the appointment list. And I got appointed to represent a guy who knew a lot more about criminal law than I did. I think maybe even before I had notice of passing the bar, I had my temporary license, and then ended up defending him in a jury trial, and and actually got an acquittal, amazingly enough. But so even though we had a public defender, we had plenty of work to do, and there were always appointments because you'd have multiple defendants, which was in my case, or they had a conflict because of some other reason. And so we all got lots of practice and experience in criminal law.
So is Geary County or the 8th Judicial District, is that a direct election jurisdiction, or is that a merit selection jurisdiction?
It's merit.
Merit selection?
77 Reform Act. It was part of that. The only exception was there was an election that very first year. I know my father and a couple of the other local lawyers got that taken care of, but most of the counties, other than Wyandotte, strong Democratic, Sedgwick, strong Republican, were part of the merit process. But over the years, you've gotten now to a point where I think it's almost 50-50 election versus merit.
Right. Yeah, I know Johnson County, that's which was where I'm primarily based at, is a merit selection. And of course, it's a large county. So, you get to sit in and see the selection committees, not deliberations, but, some of the interviews and discussions. They actually post those on YouTube now.
Oh, yeah, sure.
Which is a nice change. I mean, you get to see all the, the commentary. They don't go into, this person isn't going to work because of this reason, but they just, sort of talk about these things. To where at least there's some public scrutiny of what's going on there. Right. So let's go a little more high level on this. And let's just talk about, I kind of brought up before that you've got, the three branches of government, executive, legislative, and everybody's familiar with those. Your presidents and your governors and your state and federal legislatures. But it's a triumvirate type system, but what is the role of the judicial branch in that? I know we all hear about, back in school, Marbury versus Madison and the Supreme Court staking out its claim. But what does the judicial branch do in that triumvirate of government?
Well, obviously, it's part of the checks and balances. Because Marbury versus Madison, yes, it will decide if legislation is constitutional. The one point is, until there is a case in controversy, a case is brought before the court can't exercise any power over that. So you always have to wait for that. And the judiciary for many years, certainly in Kansas, was looked on as basically an agency as opposed to a separate branch. We would submit budgets like other agencies, those types of things. It was a problem. And even though there actually, I think most scholars would agree, there is the inherent power of the court can say, yes, you have to fund us at this level or whatever. No, you can't set up rules that govern us. We're a separate branch. We can do it ourselves. That's rarely, if ever, used by the judiciary, because how do you enforce it? The executive branch has to do the enforcement of it, those types of things, other than just basically say you're shutting down. But courts have historically allowed the legislative branch to set up things as far as age limits, those types of things. But there's still the court rules, and the court can basically step in and say, sorry, our rules overrule your legislation. So.
Because it's kind of a talking point for later on, but when they do that, when they overrule the legislature, do they have to make a specific finding on that, declare something unconstitutional, or, just come and say, hey, we're not going to follow this?
I suspect that they normally would do it formally, but I think they could, in effect, as the legislative and executive branch have done before, they've just basically ignored the court. The court could potentially do that also. For instance, if they said you have a maximum age limit of 50, the court could basically say no, and you serve till your successor is elected and qualified, those types of things, and just not appoint someone new. That type of thing could occur. Courts don't want to get into those types of situations, and hopefully the executive and legislative branch don't either. But you could always see that arise.
Well, but you do also have to have, we create statutes for a reason and go through this legislative process for a reason, pass laws, the executive signs them, and the judiciary, interprets and rules on those. You can't have a judiciary that just says, these we're not going to enforce these statutes, or this statute doesn't apply. So, without making some sort of declaration that it's somehow in violation of the Constitution.
Right. And that's what I'm saying. They would normally do some sort of formal action, but it's so rare that any of that ever occurs. You have supposedly people of reasonable minds handling these things. Of course, that was a 5-4 decision.
So drilling down a little bit, in my last interview with Vanessa Reevely, we touched on the idea that in some countries, the judge is often the driver and an investigator, basically, of criminal prosecutions. Countries like France and Italy and Spain use an inquisitorial system of justice, but we have an adversarial system. Can you kind of give us an overview of the role of the judge in that particular type of system? Is the judge just a referee, or what?
Basically, yeah, the judge is the ref. Now, obviously, in jury trial situations, that's what I am. I'm the ref. The jury is the finder of fact. Now, in a bench trial, I have to find the facts. And in those situations, yeah, I'm not supposed to go out and do my own investigation or decide on anything other than what is presented in court, what's admitted in court. The same instructions that we give jurors. So if it's a situation where I know something about it, have some personal knowledge or whatever, and potentially a bias, in those situations, I need to recuse and step aside and let a different judge handle it. And so we have that situation. And in small towns like Junction, and a lot in Kansas, I was lucky. I had a couple of other district judges there in the county, and we wouldn't necessarily, formally recuse from it. I could go into Steve or whatever and say, I know this doctor real well, or something. Right. I'd rather not handle it. Can I handle one of yours and you handle this case? And so we would do it that way. Now, of course, you can go through the chief judge and you can actually specifically recuse yourself from a case. And you would do that in a situation where you had a true conflict of interest. You previously represented the one of the parties, or you had a fiduciary relationship with one of the parties, those types of things. But there's others where you just don't feel comfortable handling it. And so it's nice to have another judge available just to trade on.
Well, I would think, given your background, your family history, I mean, clearly pillars of the community, and are more or less founders of that Junction City for the last 100 years. It's like that you would have lots of contacts, with other people in the city and the county who might have to come before the court for various reasons.
Sure, and obviously there were many occasions where I would just announce on the record, I know this individual. If anyone has a problem, I will recuse or whatever. So you give a full disclosure and let everybody know, again, because it's appropriate, and it also makes them certainly feel much better about it. But yeah, having had the history there and everything, I digress a bit here. I remember on my jury trials, when I would get the jury list, I knew most of the people on it, but anybody I didn't know, I could go to my father and, he'd examine the abstract for their family or whatever, and he could say, I don't know if you want Bill, his brother Jerry had a run-in with the police, the sheriff, or, whatever. And I know all this stuff before I went in. And it's funny, as a trial lawyer, I'd gone to tons of seminars, learned body language, all of those types of things, how to pick a jury. I just cheated because I knew everybody. And it was funny. I mean, I had people that had been babysitters of mine, on juries, and, things like that I'd known quite well. And they got left on. So it was fun.
Yeah, I remember a jury that I got, because I've been called 3 or 4 times for jury, and generally I always get kicked off the criminal ones. But Judge Anderson, who may have been a classmate of yours for a while, I got called on one of his juries, and I'm sitting in the courtroom. It's like, there's no way that I'm going to be on this jury. And he's like, no, I just want you to sit through and watch the process. I'm like, all right. So, but I go through the whole deal, and they're like, do you know anybody that's involved? And I was like, well, I've got the co-defendant on bond, and I know every single person sitting in front of the bar. And it's like, yeah, okay. And I didn't get a deal, so they didn't have to strike me. But so I've sat through that. But it's like, there's no way I'm going to sit on that.
As a lawyer, you'd love to have the experience of sitting on the jury, see what truly impresses the people, those types of things. And in Geary County, obviously, we had many, many jury trials, and people served numerous times on juries. And I got called, I think, probably half a dozen times over the years. Always had a conflict, represented one of the parties or whatever. And even as a judge, I got called, and of course, I recall on one of them, the guy was suing the county over something, and I had been the judge that had sentenced him to jail that he was suing over. So, I didn't get to serve, but yeah, I got called a number of times, rarely put up in the box. Routinely, the judge would just kind of boot me out. But yeah, I had some folks that through my years in civil and criminal jury trials, had served 5-6 times on jury panels. So yeah.
Well, it might be a little disheartening though, because I mean, I've been selected and served on civil juries before. It's like I remember one, the guy was testifying and he was dressed pretty sharp. I mean, but like in a shark skin suit, and we walk back in the jury room and first person goes, "Did you see that suit?" I'd never believe what that guy had to say. And it's like, okay, well, I guess we're making decisions based on the facts here.
Yeah, it's kind of scary, I was lucky, small community, knew folks on the jury and would be able to talk to them subsequent to the trial and find out, what they thought, those types of things. And that was certainly helpful to me. But it's kind of funny, in federal court, the judge isn't allowed to, it's kind of an odd rule. The judge isn't allowed to talk to jurors afterwards. And my dad actually got called years ago on I think it was actually a criminal trial, and it was in front of Dick Rogers, who my dad, they were fraternity brothers. They were very good friends. They'd been general counsel for some corporations together, some things like that. And I was joking with them afterwards that they weren't going to be able to go have a drink together because, Dad had been on his jury.
Well, let's talk about bail a little bit. It's bail podcast. I should probably touch on that. So let's just talk about the basics. So as a judge, what are the factors the judge is supposed to consider when setting bail? It's not just, does this person have a nickel in their pocket? What are some of the other things you're supposed to look at?
Right. Obviously, whether they will appear.
Right.
And, we've got it set up, as I recall, in the Constitution. It talks about release with surety, as I recall. In Kansas, we have that in there. But yeah, it's obviously to ensure that they're going to appear. And the other thing that the court obviously takes into consideration is safety, say for a victim or whatever. I would put conditions on the bond. Well, they're statutory conditions, but I would always specifically state again, you're to have no contact directly or indirectly with the victim in this case, those types of things. You can put travel restrictions. You can do quite a bit. The thing that the court is concerned about is obviously them appearing, safety of witnesses, victims, general public. But you also consider the fact that this person is innocent until proven guilty. And so just warehousing them or whatever, you don't necessarily want to do that. The more information that a judge has, obviously, the better decisions you're going to make. I know, what was it? I think I was in Shawnee County one time, and the judge had the public defender, the county attorney, court services, community corrections, some other people there, and got tons of information about this defendant. Able to make a very informed decision.
Right.
And so the more information you have, obviously, I think the better decision you're able to make. Again, me in a small community, having been a prosecutor, having lived there all my life, a number of the folks I did know. But at Fort Riley, there's loads of turnover there and new people coming in, so you don't necessarily know. But those types of things are, obviously what the court has to consider.
Right. So, you don't look at the person's criminal history, You
Yeah.
know, if they've been in trouble before, if they've failed to appear before on different things, you know, what they're, as you mentioned in Fort Riley, I mean, there's a certain degree of transience there. I mean, you might be, you know, if you're on the base, you might be stationed there for a little bit of time. I assume that there was a good working relationship with the MPs on base for those sorts of things.
My dad was the federal judge out at Fort Riley for a time when I was a kid. And so, you know, I knew every CG and provost marshal and SJA, all those guys over the years. And yeah, we did. I know when I was on the city commission, we had a very good working relationship with them. Our police department would go out there and do firearms training, you know, at their range, things like that. Um, it's kind of funny in the seating statute of Fort Riley, the state retained the authority to serve process on Fort Riley. And so our sheriff could actually go out and arrest anybody out there legally. But as a matter of fact, you always went through the provost marshal
Right.
and set that up, and they would have the guy then right there at the office for you to go pick up. You know, that was just certainly wise to do, because how's the sheriff going to find the guy anyway? But also kept good relationships. And, you know, I mean, there were some occasions where you had a sheriff or a provost marshal that was a different guy and they didn't get along that well, but by and large, it worked out very well.
Well, that's sort of an unusual, in my experience. You know, generally you can't do those things on federal reservations, whether they're military bases or Indian reservations or whatever, you know, federally controlled lands. You know, you're sort of, you know, hands off on that. You've got to work through the federal people in charge there.
Right. And I suspect that most people wouldn't even know that. I knew it because my father told me.
Okay.
You know, that type of thing. So yeah, but we historically had a very good working relationship with them. And it was kind of funny, you know, for a number of years, Fort Riley had the retraining brigade, USACA, USAR, but not really different acronyms. It was their program where they, instead of booting somebody out for committing a crime, they tried to retrain them and keep them in the service. Well, their failures were our caseload. And so, you know, it was kind of funny. On occasion, I would get a guy that, you know, is military with a, you know, felony criminal record. And normally, you know, that wouldn't occur, but
Right.
because of that retraining brigade, yeah, we had a few career guys there.
I mean, I guess, you know, I would assume at some point the military is going to be like, yeah, this is one chance too many.
Yeah, they ultimately get booted if they don't make it through the program. Yeah.
Right. Well, let's talk about bail reform a little bit. And when we talk about bail reform, at least from our perspective, what we really mean is a movement away from any sort of financially secured pretrial release. I mean, you have, you know, signature bonds, you know, cite and release, those sorts of things. But it would seem like from a judge's perspective, and, you know, forgive me if I'm inserting my view into yours, the entire purpose of bail reform and these bail reform lawsuits we've seen is to take away some degree of judicial discretion. And I know from direct experience working in the legislature that the judges get all kinds of upset when you're proposing limiting their discretion to say restrict signature bonds or OR bonds, but it doesn't seem like the same reactions there. They don't get as worked up when bail reform proposes to take away their authority to deny OR bonds. Kind of curious what your thoughts on that, or what the judicial perspective is on bail reform, you know, requiring the courts to release people without any sort of security.
Yeah, over the years, obviously, you've seen the legislature do mandatory sentencing guidelines, those types of things. You know, I even know as a prosecutor, you know, you had situations come up where you say a DUI, you couldn't negotiate that or whatever. You always figure out ways around it. As a prosecutor, you just dismiss the case and refile it as a lower crime or whatever.
Right.
But as judges, you've normally seen historically that when somebody tries to get involved and skew the system one way or another, it's because they have some special interest in doing so, and it doesn't usually have good results.
Right.
You know, certainly judges make mistakes. We all do. You know, but you have to be judged on the decision you make based on the information you have or what the person's charged with or whatever. Yeah, I would suspect that most judges don't like the interference into their prerogative, what they deem appropriate. To tell you the truth, you know, I've been off the bench now 9 years. I really didn't run into too many problems. You know, made rulings and figured out ways around restrictions. And so I didn't run into it as a problem most of the time.
Well, this version is relatively new.
Yeah. Over the years, I mean, we've had variations on bonds. I remember we did, as a prosecutor, we prosecuted bad checks. And so we actually had a situation come up where we wanted a cash bond where they could forfeit it and then that would pay off the bad check.
Right.
But what we added on there was you could have a $50, you know, cash bond or a 500 surety. So you had the option when we had the cash, we always had the surety on there because, like I said, my recollection was Kansas Constitution talks about surety in the release. Now, OR bonds, I would say we'd see them in misdemeanors, rarely felonies, unless at a subsequent hearing, first appearance, preliminary, whatever, the bond got modified. And there would have to have been some evidence for that.
Sure.
I suspect that it was extremely rare to see an OR bond on a felony warrant. I'm sure it happened, but it wasn't routine.
Well, we're seeing jurisdictions, even in Kansas, where, you know, the person will fail to appear and they'll issue a bench warrant and they'll set a signature bond on the bench warrant, which just boggles my mind. This person has already failed to appear. Right. Why would you just cycle them back through on that? I mean, at least get them in front of the court to see what's going on.
Yeah. I can't ever recall doing anything like that. And I certainly can't understand the logic behind doing that. Again, like you said, at least have them in front of you where you can find out, you know, was there some good reason for this or whatever, you know, but no, that would be, I think, rather foolish.
Well, the logical consequence of bail reform over its term. So basically, you know, the idea is, you know, people come in, these bail reformers, and they want to turn around and get everybody released right away. Well, then you typically will see a pretty significant increase, you know, spike in crime following that. Whether it's the same people or whether it's just the lax enforcement that creates the environment to where it's like, well, there's no consequence for doing this action. I'm not going to have to postpone. If I get arrested, they're just going to let me go again. What that then leads to, I think, is you're trying to, you know, move people more towards like the federal system of using preventive detention. So we sit there and say, okay, you know, I've made a determination there's no combination of money or conditions or anything else that can make sure you show up for court. So we're just going to hold you in custody. And that sort of came from the Bail Reform Act of 1984 and is largely used in the federal system.
Right.
But what's happened in the federal system is that's gone from, you used to have about 25% of people that remained in custody for the duration of their case prior to 1984 to now you're up to about 75% of people in the federal system remain in custody for the duration of their case. I guess I'm getting out of order my questions here, but you have been obviously a district court judge, but you've been a prosecutor and a private attorney, and you've also been involved in local governments. How would a system of preventive detention impact local governments if it was implemented at a local level and you had to start detaining large percentages of the people that are charged? Can governments really afford, local governments afford to hold that degree of people?
No, what you'd see is, for instance, one of the cities in our jurisdiction would do first-time DUIs, but would not prosecute second, even though it's still, potentially misdemeanor or whatever, because there was going to be the mandatory jail sentence, and the city was paying the county to house its prisoners. And so if that type of situation came up, what you'd find is, municipal courts are courts of revenue. And, even when I was on the commission, I think we probably in the 70s, late 70s, early 80s, budgeted $500,000 in Junction City, as revenue from our court. And if we would have had a situation come up where we were going to actually have to house that person until the case was over, or they had a mandatory sentence or something like that, we would repeal that city ordinance and let it be prosecuted in the county.
Right.
City, government, I mean, they're not going to be stupid about it. They're looking at revenue, what it's going to cost them. On the other hand, when I was in the county attorney's office, I would have situations come up where the police had arrested somebody on something, and they had forwarded the police report to me in the county attorney's office, and the city had an ordinance against it. Many times I would just put nolo prosequi, refer to city attorney, let him file the case, because it was a misdemeanor and we had plenty of caseload. But yeah, I would think that absent somebody not looking at dollars and cents, cities would just not enforce that or would repeal those municipal ordinances.
Well, and that was the tactic that was used by these bail reformers. Like, I don't know if you're familiar, there was a lawsuit filed in Dodge City against the city proper. And they actually would go around to these smaller cities that would have bail schedules that they used and then sue them and claim that those were unconstitutional because for a variety of different reasons. But basically what they would do is essentially force settlement agreements out of these cities because the cities didn't have, $200,000, $300,000, $400,000 to go fight these sorts of things, these activist groups in federal court. And they would always file them in federal court. Sure. To where which was the most expensive possible venue to tackle a case in. And so the cities would just settle these, and so you'd have this settlement agreement, and then they'd come back and go, well, look, these courts have already determined that this bail schedule is unconstitutional, and so then they would go to these large things. Well, we're going to sue you, and we already have this track record. Until you actually got larger cities that they try this in who said, no, we're not gonna fold to that. And so then it actually, as you brought up before, there had to be a question and controversy for the courts to make a ruling. So you have to have parties on both sides willing to litigate that controversy. And so when you get to the appellate level, the appellate courts are like, yeah, no, this is, we're not doing this.
Right.
But that was a tactic there.
Yeah, I was lucky when I was city attorney. And also in private practice, I represented some insurance companies after having done plaintiff's work. And the agreement I always had with them was, look, if it's a legitimate claim, pay it. Don't mess around, take care of it. If it's just a nuisance settlement they're looking for, those types of things, fight it all the way. It's going to cost you money on the front, to fight this thing, but if you just give in, you're an easy mark and everybody's going to come at you.
Sure.
So I had that basically as my agreement with the city manager, with the commission when I was city attorney. We wouldn't fold on those. But as sometimes happen, you get a little different personnel that are commissioners and they change their minds on things. Likewise, I had insurance companies that then would come to me and go, well, how much money does this defendant have? How good's their lawyer? Those types of things. And at that point, I said, get another lawyer to represent you. Yeah. So it was lucky for me throughout my career that I wasn't hungry. I was able to pick what cases I wanted. When I prosecuted for two different county attorneys, the agreement I had with them was, you assign me this case, fine. I'm going to handle it the way I deem appropriate. If you don't like the way I'm handling it, it's yours. You handle it.
Right.
Because, I didn't ever have to worry about the politics of it. I could do what a prosecutor's supposed to do and do what is just. So I didn't have to do something showy to show that I was tough on law and order, or those types of things that you see skew the system and you see as a problem with some prosecutors. So I was lucky in my years practicing.
Well, and that can be skewed both ways. You have the I've got to be the maximum Bob, like this book behind me here, where I've got to be ultra harsh, or you have our progressive prosecutor thing that's going on now, where we've got to be ultra lenient because we've got to offset some theoretical problem in the system.
Sure, and obviously, as a prosecutor, you make decisions on all of these cases. You have to do what is just. As a judge, likewise on sentencing, I mean, I had some situations come up that I thought, how did the legislature ever come up with this type of situation? But in any event, you're always going to have those isolated incidents. But as far as setting a policy that you're not going to handle a type of case, somewhat problematic. You're sworn to uphold the law and those types of things. So there certainly can be those situations where morally you think the law is bad. You can always prosecute them, but you can always lose.
Right.
I mean, it's pretty easy to do that. Like I said, no matter what the legislature does or what somebody else does, you can always find a way around it.
Well, I mean, if you're talking about, like adultery still being on the books as a criminal prosecution, that sort of thing. But I mean, it's a whole nother deal when you're talking, well, I'm not going to charge people for theft, if it's below a certain amount, or if it's, against Walmart versus some small business. There's not a moral issue there. That's a political issue.
Right. Now, I can recall as a prosecutor, I had a situation come up where I had I think he was a lieutenant colonel, and sodomy was still, a violation, and was going to get him booted out. He had 19 years in the military. He was ready to retire, those types of things. And his defense lawyer came to me, and we figured out a different charge that worked on it, and he pled to disorderly conduct. And I won't explain the factual basis behind that, but yeah.
No, I understand.
So, I didn't prosecute a sodomy case. That's true. I modified it because under the circumstances there, I thought that was the just thing to do.
Well, and I think I think basically prosecutors in general had stopped enforcing that particular statute or even the adultery statute long before it was actually removed from the books.
You bet. Yeah.
I do have an interesting story from when I first started out years and years ago. I don't know if you're familiar with David Gilman, who was a attorney here in Johnson County for a long
Sure.
time.
Oh, yeah.
He had a charge. It was some sort of aggravated battery charge. It was basically the husband came home and found the wife with some other guy, and then proceeded to beat the hell out of the guy that she was with. And then the defense was, well, I was trying to make a citizen's arrest for adultery.
Yes.
And so I don't recall how that all came out. I just remember the scenario that was the defense that was brought up. I was justified in doing this because he was committing a crime in my presence.
Right. And I had to, yes, subdue him numerous times.
Exactly.
I remember Dave telling that story. Dave and I tipped a few over the years. So yeah, I heard a lot of those good stories.
So let's talk a little bit about judicial accountability. When my son, this is kind of a long one here, but when my son was in Boy Scouts, I was volunteered into teaching the law merit badge. It's like nobody else was a lawyer, and I was the closest they had in that troop. So you teach this. But one of the topics we covered was the Code of Hammurabi and the Magna Carta as well. And code number 5 in the Code of Hammurabi, I wouldn't expect anyone to just pull that out, but basically was if the judge made the ruling wrong, the judge could be held accountable for that down the road. And in bail matters, as I looked at history of bail issues, it's not the Magna Carta, but it's the one of the statutes of Westminster or something that came afterwards, that the sheriff could be removed from office if he took insufficient surety on posting a bond. So basically, if he said, okay, this is a sufficient surety, and the person didn't show up, the powers that be, which presumably would be the king, could remove the sheriff from office on that. Don't know how often that happened, but it was in there. Now, I recently attended a bail bond conference, and one of the complaints that was raised by these people in the bail bond industry was one of judges refusing to follow the law as relates to bail. Now, part of the argument was these people had worked really hard to pass or defeat legislation to only to have judges basically completely ignore, the law that had been passed or the change of the law that had not occurred. And mind you, they were not arguing that there was a finding of unconstitutionality by the courts. The courts were just saying, we're not going to do that. We don't care what this is. We're going to do what we want. And actually, even closer to home here in Kansas, we have the ORCD bond is allowed, which is the 10% deposit bond, but only in certain circumstances. And like probation violations is not good. If you're an out-of-state resident, prior failure to appear. Well, I've seen instances where bench warrants are issued with an ORCD on the bench warrant for failure to appear. It's like, well, that is on its face a violation of the statute. So what is the system of accountability for judges if they decide to simply ignore the statute on this stuff?
Well, ethically, I think a complaint could be made about the judge, and he could be brought before, in effect, the judicial disciplinary panel, basically. That certainly, I mean, failure to know the law and to do that is an ethical violation. So that would be one recourse. Now, I don't like election of judges. I think it's rather absurd to have political parties and one lawyer represent, supporting this judge and
right.
Another one didn't support him, and you're in front of him and he's supposed to be fair and impartial. Never did like that. But in any event, obviously you can vote them out. Now, that many times creates a problem because judges should never take into consideration public opinion when ruling on the law. Now, obviously an elected judge more so, I suspect, than someone that's just up for retention. I think historically you would find that they do go with public opinion more so. But if I'm not willing to make the right decision, yeah, I think that reflects on my character as well as anything else. But yeah, I shouldn't stay there as a judge. So, but you know, yeah, you've got the recourse as far as the ethical violation or booting them out.
Well, and your comment on the election of judges kind of leads me into the next question I had here was like on big press cases, especially at the federal level. We often look to see which president appointed the judge to try and handicap the ruling before it comes out, and oftentimes we're not wrong. And we routinely see 5-4 decisions from the Supreme Court, which is, or it'd be 5-4, yeah, it's 9. Which is presumably, the Supreme Court's presumably comprised of the top legal minds in the country, and yet they can't agree on exactly what the law is. So I recently did a podcast, just a talking podcast, criticizing the decision of the Illinois Supreme Court in failing to strike down the Safety Act, which seemed to me to be a blatant violation of the state constitution. And that was the dissenting opinion was, yes, this is a violation of state constitution, but the majority opinion held that it was not. But this sort of begs the question, are judges, as you mentioned before, are they beholden to the law, whatever that is, or are they really just politicians in robes?
Yeah, I hate seeing that type of situation. I also hate seeing that in Congress. I think legislators are there to do what's in the best interest of the country, not their best interest to get reelected or what the party wants or whatever. But obviously we see that. It's not new. I mean, if you look back, anybody that was in law school and looked at some of the old cases, I mean, the railroad never lost, and then, after that, the insurance companies didn't lose and those types of things. So, you had a Supreme Court many times that came from big firms that represented big corporations, that type of thing. And as a matter of fact, in Kansas, for the Court of Appeals, I think twice, the Kansas legislature turned down a guy that had been a public defender, citing the fact that he'd represented criminals and therefore didn't appoint him to the Court of Appeals. And I thought, how absurd is that? I mean, the guy is required to represent his client. But again, it played out politically for them, I guess. But it has bothered me over the years, just watching some of the cases and seeing the tortured logic that they use to justify their position. And it is kind of funny. I won't mention the justice's name, but in one of the cases that I sat with our Supreme Court on, where I got appointed by them, we were back in chambers arguing about something, and I had made an argument about what the situation was, and one of the justices turned to me and he said, trying to think exactly how he phrased it, I can't come up with his exact terminology, but in effect he was saying we don't always have to be intellectually honest. It was what he was coming up with. And so you have seen over the years that sometimes courts had a predetermined decision and then basically researched ways to support it.
Right.
And that's too bad. It shouldn't occur that way. But I think you're even going to see it more and more. And it bothers me that people are accepting of that. We always joked as a lawyer, you didn't want a fair and impartial jury. You wanted one that, supported your position. But, if you're looking at courts that way, unless you're the richest guy or the most powerful guy around, you're going to get second place a bunch of times. And so, you know, don't wish for that. And we shouldn't have that, obviously.
Well, I mean, Judge Vano, when we were talking one time, said, one of the important aspects of law was predictability. So you knew what the law was supposed to be. You knew what the consequences were if you violated it. You knew what where you could push up to the boundaries of it. But predictability is one of the most important aspects of law. And if you don't get that from the courts, if the courts are sitting there changing the goalposts of what the law should or is, then you don't have that same predictability.
As I referred to earlier, the reasonable mind standard, men of reasonable minds couldn't differ on the outcome, was a 5-4 decision. That was always the joke about that. But yeah, it's bothersome to me when I see those types of situations come up, or I hear comments from judges about those types of things. Some of our present Supreme Court justices in some presentations have made some comments about the way they feel about certain things, and shouldn't be that way.
So you've been off the bench for a while, so let's, we can go a little softer here. So are you enjoying your retirement? Are you one of these judges that's working more in retirement and than they were before, or what's going on with you future-wise?
It's kind of funny. I was planning on working 4 more years, 1 more term, but my wife retired and bought another house and let me know. And so I assumed that I should, live with my first wife. So I went ahead and retired when I was 62, 9 years ago. But I had filled in for some other jurisdictions. I knew judges in all of the other counties around. I went back and handled a couple of old cases that I had, so that the judge that had it now didn't have to go through and read voluminous pages of transcript to be able to make a decision. And I handled a few of those things, but I finally got to the point where I was saying, well, if you can't find anybody else, I'll, fill in, to finally just saying that I'm done. No, I've enjoyed the retirement. Haven't golfed for a while, but I was golfing quite a bit, traveling. I've got a couple of kids. My daughter lives close to our one home up here in Kansas City area. And she's a doctor up here, and I have grandkids. Oh. My son's in Austin, and we're close to the airport. I can fly down there and see him routinely, and the boys. And so, no, I've enjoyed it a lot. My wife and I travel. I've got loads of friends, and can go out hunting and motorcycle riding and all of that. I've got a buddy down Table Rock, go down there routinely. So yeah, I'm
enjoying your time away from all this.
Yes. It's funny though, for years on Friday afternoon, I'd still pull up the cases and review what the decisions were, from the Court of Appeals and Supreme Court. Now, I don't do that every Friday, but I still on occasion watch.
Might be difficult to do for a while until they get this computer system back up and running again.
You're right.
Well, exactly. Judge Platt, thank you for taking the time to talk to us today. I think that, like I said, most people don't really understand the role of the judges and even the judicial branch in our system. So I definitely want to thank you for giving us some new insight. It's, we don't often get to talk to judges because they tend to, I don't want to, involve myself in this. So it is nice to get that perspective.
Yeah. As a retired judge, nobody's holding anything over me. So yeah, I can, I can say it without any worries.
All right. Well, sounds good. Thank you for taking the time today.
Thank you. My pleasure.
We want to thank our guest, Judge David Platt, for taking the time to talk with us today. We often overlook the role of the judiciary, except when hot-button cases like abortion and gun control are in the news. And then we alternatively criticize or praise the courts depending on the side of the issue we're on. It is incredibly important that we understand the role of the judiciary in our system. Hopefully, this discussion has shed some light on the role of our local judges. We hope you'll join us next time for another episode of the Bail in the Midwest podcast.
Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf.